you should have the feeling that you have seen the Commonwealth versus Patrick case before. In fact, you kind of have. In Commonwealth versus Thomas, we saw a very similar version of this case in which the defendant died. And the question was, in that case, whether the single punch by the defendant could amount to third-degree murder. And as the court talks about in the Patrick case, the aggravated assault statute, or many provisions of the aggravated assault statute, are essentially the statute that applies when the defendant's conduct would amount to third-degree murder if his victim had died. So in this case, the defendant, Patrick, his victim, Liz. You get a single punch to the head. It's a sucker punch, as they describe it. The victim didn't see it coming, and the victim falls flat back on the ground. And in this case, it causes severe brain injury, and he's in a coma for 2 days. If this victim had died, we'd be asking the question of whether this is involuntary manslaughter or third-degree murder. And in this case, the court looks also at the Roche case. And in Roche, we have a nearly identical set of facts. You have a single punch by a defendant to the victim. Person goes back on the concrete, suffers severe injuries. Is this aggravated assault within the meaning of this statute? To ask this another way, as the Commonwealth itself recognizes in this case, does this constitute recklessness that shows an extreme disregard for the value of human life? That was the very complex case we just looked at before in the Nichols case. In Nichols, we saw that what we're asking is whether this involves recklessness that rises to extreme indifference to the value of human life. That's also malice. And that's what the Nichols case told us, and that's what we're now learning again in Patrick. Patrick again tells us that recklessness that shows extreme indifference to the value of human life is malice. Recklessness that merely shows that you're taking an unjustified and substantial risk to serious bodily injury that would be a gross deviation from ordinary conduct, that amounts to the lesser standard, that's not the degree of recklessness that's required for malice. So now, applying the facts of this case, the single punch from Patrick, looking back to Roche and looking back to the Thomas case where the victim died, in Roche, of course, the court also says that this is not enough to show malice, and this is therefore not aggravated assault. In this case, of course, the dissent says exactly the same thing. The majority does not reverse or does not dismiss the case against the defendant in this case because of the procedural posture. And that procedural posture is simply that we haven't yet gone to trial. We don't know what else we might learn, that these allegations might be enough when fleshed out with the facts at trial to show more than just the single punch. The dissent, though, says, wait a minute, no, you look merely at the indictment, and all that's alleged here is what was alleged in Roche and in Thomas, and that's the Commonwealth has not yet alleged enough for malice. The dissent obviously presents a cleaner picture of it, and understand that the difference between the dissent and the majority in this case is just simply a procedural question. At what point would we have to wait for to determine that there wasn't anything more than a single punch? If we go to trial, there's just a single punch. That's not malice. That wouldn't be aggravated assault. That wouldn't be third-degree murder. And the real question between the majority and the dissent is, how much has to be alleged up front? Do we give the Commonwealth some breathing room to prove at trial more than more than the bare bones of the single punch that's alleged. And think about the only distinction here. I mean, the defendant could then be charged with ordinary assault, and the case go to trial, or in the case of the death, could be still charged with involuntary manslaughter. The only question is whether whether we first hear the facts before we make the decision about whether this is enough for aggravated assault, whether this actually shows reckless indifference to the value of human life, or just reckless indifference to a substantial and unjustified risk of serious bodily injury, whatever that distinction is. But as we've talked about, there will be rare times where the court will give us some guidance. And this is one of those times. There will be rare times when the court gives us some guidance as to what is sufficient. And so this is one of those times that, again, the court is saying that a single punch, if that's all you got, that a single punch is insufficient to show malice, and therefore insufficient to show that first prong of the aggravated assault statute that we very methodically unpacked in our video on Nichols.